We are live.
Good morning. This is Thursday, April 27th, 2023. This is Senate Judiciary Committee. Just to correct the vote yesterday on H230, we had 3 votes on 3 separate parts of the bill. And I will say that the committee was split on a number of issues. The final vote was for the bill and 1 against. And if we had it to do ourselves, we probably would have done 3 separate bills, but it was the way the House did it, the way it came over from the House. So we did have 3 separate votes on the 3 separate parts within the committee, which might have created some confusion. But the final vote was 4-1. Cleaning that up, we're taking up H45, an act relating to abusive litigation filed against survivors of domestic abuse, stalking, and sexual assault. And with us this morning first is Judge Thomas Zone, the Chief Superior Judge for the Vermont Judiciary. Judge Zone, welcome.
Thank you, and good morning. For the record, Tom Zone, Chief Superior Judge. I have had an opportunity to review the most recent version that made some changes up in the definitional area in Section 1, and I support that. I think it responds to the concerns and questions that had previously been indicated by the committee as far as clarity and setting forth a process. And so I would support that. Beyond that, I don't have anything else to add. If the committee has any questions regarding it, I certainly would be able to address them, hopefully.
I do have a question to start with, and it may sound rather mundane, but I always thought that judges could dismiss actions on their own volition if they felt there was an abusive nature to them, or if they were frivolous, or if they were just trying to get back at someone.
There are specific rules of procedure that would allow you to strike scandalous and impertinent and other filings, but it doesn't rise to the level of a judge saying, well, we're going to dismiss this whole case. Generally, it allows you to it could have that net effect, but in practice, that's not generally what happens. But this bill, I think it should be viewed more of a, again, specialized bill, because when you look at the criteria and it focuses on the domestic violence issues, it really is, as I see it, a bill designed to go and provide a remedy for individuals such as the witnesses you heard from, who talked about the impact of the litigation in generally the family division, but sometimes there will be civil suits filed. Sometimes there will be suits filed in several of our divisions. And this bill is really a focused attempt to provide a level of protection when the rules of civil procedure and the rules of family procedure weren't designed to really address this type of conduct. We have Rule 11, which does provide an ability of judges to do that, to enter decisions that, if you will, push back when we have frivolous litigation or abusive litigation. But this specialized bill, as I see it, identifies a specific class and category of litigation with individuals who need protection that Rule 11 just isn't designed to address. Can we do it and utilize Rule 11? Yes, it could be fit there. But I think what we've seen is that Rule 11 has not provided the mechanism for this particular category of individuals with a level of clarity for all the judges and for all the litigants to know this is out there as a mechanism to protect. And so while the Supreme Court did it in Fox v. Fox, is the case that the committee heard about. The Supreme Court in a case called Zorn had pre-filing restrictions, but they were done, a Fox case was not done under this type of statutory protection. And without that, it is something that, again, you can do under Rule 11, but it's just not designed for that.
Thank you. That's helpful. Other questions for Judge Zone? Is the effective date of, I might have asked this before, but is the effective date of September 2023 work for the judiciary?
I believe we can make that work. The only delay, the only issue that might be there is the development of the forms, but I suspect we can get that done because it does require forms, and I think we have the ability to take care of that.
Good. Well, if you if the Senate version of the budget passes, you'll have 5 additional.
And that would be very helpful. And I cannot tell you how much we appreciate that.
Well, hopefully the Senate version will pass.
And you also mentioning that with the additional judge this morning, I began my day with requests for that we need additional judicial resources in certain courts. And my response was, well, if we have these additional judge position and the new appointments come through, that will certainly help to alleviate some of the stress that we're trying to alleviate with retired judges.
Yeah, good. Thank you, Judge.
Well, thank you. And if it's okay, Senator, I would note that I am unavailable after this morning, and I do see that S91 is on. And if it's okay, I'll just let you know that we take note. We have no objection to the changes that are coming over from the House.
Okay, great. Thank you.
All right. Thank you. Have a safe day, everyone. Take care.
Any other questions from the committee for Judge Zone?
Nothing in the room.
All right. Michelle?
Thank you.
Yes.
So we've been over the changes in draft 1.1, correct?
Correct.
And I'm looking at it on my iPad, and so I'm reading a lot of yellow in the definition, and that's really what we redid.
Correct. Is it okay if I sit in your chair right now so I can see you while I'm looking at my computer?
Absolutely. You can even adjust it, Michelle. I'm fine.
I kind of like it up high like this. It's good. So did you want to go through the bill again, or I mean the only changes were to the restructuring?
Well, walk us through. Would you walk us through the definition at least?
Sure.
And any other changes?
Would you like me to share my screen?
It'd probably be helpful for those that may be watching on Zoom.
Okay. Hold on, I didn't sign on yet, so let me take a minute to do that.
Where'd you get that information you gave to me the other day?
What
Did you look up online, the actual voting population in Elbert?
no, so the witness that we had from Albert, yeah, she gave us that information in the testimony.
Remember what that was?
I wrote it down in the box, so I can get it.
I go back and I'll pick up my presentation anyway, to help it down there. I'm gonna stand in front of the mirror practicing last time. I was.
Okay, so I've got up on the screen, this is on your amendment. And essentially what we did, and again, I have to give big props to Judge Zone, because he's the one who kind of restructured and said, what about this? And I just had to do a little bit of tweaking. So I was glad he came in and said it looked good. Creating the new definition of abusive litigation, you'll see there in subdivision 1. It means litigation where the criteria below in each of the subdivisions is found to have been established. So the first one is the relationship between the parties. So subdivision A is that the opposing parties have a current or former family or household member relationship. Again, remember the household relationship is already established and by definition within the abuse prevention chapter in Title 15. Or there's been a civil order or criminal conviction determining that one of the parties stalked or sexually assaulted the other party. So the civil order is the Title 12 provision where you have orders against stalking or sexual assault. So those are the orders that folks can obtain if there is not a household member family relationship. So subdivision 1B, this is the second requirement, is that the party who's filing, initiating, or advancing, or continuing the litigation has been found by a court to have abused, stalked, or sexually assaulted the other party. And then it has a list, and the subdivisions within subdivision B are examples of how you can show as evidence that the court has found that the party filing the litigation has abused, stalked, or sexually assaulted the plaintiff. And so moving on to top of page 2, first one is that there's a final order for abuse prevention between family or household members. So this does not include the temporary ex parte emergency orders, just the final orders. It could be a final order issued pursuant to the orders against sexual assault or stalking that are in Title 12. Could be a final foreign abuse prevention order. So that just means something that is similar to our order that was issued in another jurisdiction. Could be an order under 665A regarding parental rights and responsibilities, and that's a specific section that deals with conditions of parent-child contact in cases where there has been a demonstration of domestic violence within the family. The next one is a conviction for either domestic assault, stalking, or sexual assault. And then the final one is that there's been a court determination of probable cause for a charge of domestic assault, and the court has imposed criminal conditions of release pertaining to the safety of the victim in that particular instance. So the third requirement for abusive litigation is that the litigation is being initiated, advanced, or continued primarily for the purpose of abusing, harassing, intimidating, threatening, or maintaining contact with the other party. And then, when we get later on in the down in the bill, there are things that can help inform the court in terms of them making that determination about whether or not it meets that standard with regard to the person. Is the person primarily filing for those purposes?
Well, of course, they would say they're not. Right?
Sure.
I mean, so so the court has to make a determination?
Yes, and then there are factors that the court can, do you want me to skip down or you want me to finish this?
No,
The
finish the
definition.
walkthrough, but when we come back, I'd like to more fully understand, even if somebody's purpose is abusing, harassing, intimidating, threatening, or maintaining contact, they're going to deny that it's for that purpose.
Right. So I'm just looking for that language. So if you look at this section here, I'm talking about the hearing, you'll see that at the hearing, evidence of any of the following shall create a rebuttable presumption that the litigation is being initiated, advanced, or continued primarily for the purpose of harassing, intimidating, or maintaining contact with the other party. So the first one is that the same or substantially similar issues between the same parties has already been litigated within the previous 5 years.
Okay.
So if the same issue, same parties has already been before a court and been disposed of. Page 6, top of the page, is that the same or substantially similar issues has been raised, pled, or alleged in the past 5 years and were decided on the merits or dismissed. So again, just kind of trying to prevent the same issues from being brought before the court again and again. Subdivision 3 is that within the last 10 years, the party alleged to have engaged in abusive litigation has been sanctioned by a court for filing one or more cases or petitions, motions that were found to be frivolous, vexatious, and transient, or brought in bad faith involving the same opposing party. So that could be like what Judge Zone was talking about. Maybe there's been some action by the court under Rule 11. And then subdivision 4 is that any court has determined that the party allegedly engaging in abusive litigation has previously engaged in abusive litigation or similar conduct. So it doesn't necessarily mean that they already have an order restricting the filing of abusive litigation, but if the court has the kind of, especially if you're talking about family court and that judge is kind of seeing those parties cycle through and they'll have the record and they can kind of look at the record and say, you know, as a whole, it looks like they have previously engaged in that. So those are all things that the court consider, and this is not an exhaustive list because it's going to be certainly a case-by-case basis where the court's going to use their discretion in determining whether or not the litigation is being filed primarily for the reasons of harassing the survivor. So I'm going to go back up to where we left off. I remember. And then, so the fourth thing that has to be there, so there's 4 things that we're going through that have to be a part.
That's helpful, Michelle. Can I just,
Sure.
the word vexatious, I wasn't sure of the meaning of, so I looked it up. Annoyance or causing or tending to cause annoyance, frustration, or worry. With the average person.
Actually, that is a term, I think you raised that before, and I think Judge Zone talked about it, not this time, but this time before, about that is something that is, I think, used in Rule 11 and a few other places. So it's not an uncommon term. I don't, you know, if you're opposed to it, I don't think it's, you know, absolutely necessary, but I don't, it's not, it's not like an obscure legal term. I think it's just plain language.
Okay.
So subdivision D is the final requirement, which is that at least one of the following applies. So the claims, allegations, or other legal contentions are not warranted either by existing law or by some kind of reasonable argument that existing law should be modified or changed. Top of page 3, the allegations and other factual contentions are without evidentiary support and are unlikely to get evidentiary support after a reasonable opportunity for further investigation. And then third is that an issue or issues that are the basis have previously been filed with the court and have already been litigated and disposed of unfavorably to the party who's filing or initiating or advancing the litigation. So again, it has to meet all 4 of those things in order to be considered abusive litigation. And then, you know, and I don't know if you want me to walk through the rest of the bill or, but essentially, if you meet this definition, what it results in is that the court can issue an order restricting the party's ability to file new motions, new litigation against their survivor, unless they go before the court and essentially have the court vet that new proposal of litigation or motion in order to make sure that it is not meeting the definition of abusive litigation. And if it doesn't meet the definition of abusive litigation, if it's a brand new issue and it's valid and it's not, and the court determines that it's not primarily being used to either harass or contact the survivor, then the court can give them permission to proceed with the litigation. But it just provides for an essential check on the party to make sure that they're not continuing to engage in that behavior. Did you want me to walk through the rest of it or?
Can't hear you.
We can't hear you, Senator Sears.
Sorry, well, I was muted. Yes, I think it would be a good idea to, if the committee wishes, to walk through the rest of the bill so that we're fully ready to act on it. If there are other questions or anything.
I don't have any further questions. I think I've got a pretty good idea.
Grasp on the bill, I don't,
Yeah.
we're good.
So evidently, we're ready. I kind
Can
of
I
would
ask
like
you one
to,
thing, Senator Sears, is so when I did the amendment, I initially did it as a strike all just so you could have it all together in one document. But because you're really only changing the definition and then a few words in another section, do you want me to do it as an individual instance of amendment, or do you like it as the strike all instead?
well, if I were to report the bill, I would prefer a strike all because I think it's easier to explain the bill, particularly when we
Sure.
need to go to different sections. If I were reporting, I would go from definition down to what we went to and went through this morning.
Right. Yeah, that
So
makes sense.
it makes it a little easier to do for the reporter, and it also makes it easier for the Senate to understand what we're doing here.
Okay, great. Well, this has been edited. All I have to do is take out the highlighting, but if you wanted to vote on it, it's ready to go. So up to you.
I'd rather have Senator Baruth here.
I can text Ashley.
Yeah, if you could. We could, it's fairly,
I'm gonna run down there.
no, I don't have, Peggy.
I don't mind, it's easier. I'll be right back.
We can stand,
He was right outside the door.
well, that was easy.
Very easy.
The question is the draft 1.1 of H45, and the changes are in the definitions, and Michelle just went through them with us.
There's no changes from what I went through before.
And we just went over them again, and Senator Sears asked the same questions he asked before. Got the same answers he got before, so. But Judge Zone is in support of the changes in definition, feels they're helpful to the court. So. Any further discussion? First motion is, I think, from Senator Hashim to report H40, to amend H45 as seen in draft 1.1.
Yes. Well, that sounds good.
I'm glad I moved that.
Yeah.
All those in favor say aye. Aye. Opposed? Okay. Now the question is, shall the bill be reported favorably as amended? Is there any further discussion on that? Hearing none. Peggy, could you please call the roll?
Senator Baruth,
Yes.
Senator Norris,
Yes.
Senator Bukowski,
Yes.
Senator Hashim,
Yes.
Senator Sears.
Yes. I'd like to report this. So. And I will take it up next Tuesday once you get it finished, Michelle.
Okay, I'm just now sending the clean version without the highlighting to you and to Peggy, and I will work on a section by section for you.
Senator Sears. Sorry.
Pardon me?
If you wanted to go today, it's okay for another member to bring it up. They just need to.
No,
let them know.
I don't think, I don't think there's a huge rush to get it on we get it on the calendar and assuming I test negative for COVID, I'll be up Tuesday and we can do it then. It gives me more time to get rid of the highlighting and do her thing.
Okay.
But if I test positive, then yes, I'll have somebody else bring it up. All right. Well, let me go back to the agenda, which
Yeah, I was that excited.
Weren't even invited.
I was like, I know that laugh. That's Rebecca Ramos outside our door.
well,
Almost again.
we have we scheduled an hour and a half for this.
You're so efficient.
Today we are.
Are too efficient. Can you see if Ben's available at 10:30? It's an hour's break.
Yep, I can try for Ben. I can tell you, Eric just emailed me. He is not available till 10:45.
Isn't
So-
Eric?
He's after Ben. For S91.
Good. Gotta go back to the hotel.
What do you need back? So,
Forgot my
I'm
paper.
covering,
My presentation.
2 bills for Ben.
No, he's.
I could do that, actually.
He's-
Which bills are you covering for Ben?
Okay,
All right, okay.
We're
Next
we're
one.
looking at S14 and S91.
Yep, okay. And Eric can't be here till 10:45, so do you want to just wait and go at 10:30 and do both bills, or do you want to try and do one now, wait again?
Well, I could do S14 whenever Ben's available.
Okay,
Yeah, I think he's available by Zoom.
yeah, let me know right now, hold on.
Okay.
Is Ben going to be here today, Michelle?
No, they are on baby watch.
Okay.
And so Eric and I have kind of divvied up Ben's workload. Those are a certain bill or issue.
Yes, the second one on the calendar today, I'm doing.
Oh, right. So I'm going to cover that for him.
I'm gonna go offline